judgments?
Well, yeah, I mentioned before, the legal standard the court is supposed to use is best interests of the child or children. And that isn't always clear. We often, in real disputes that aren't resolved by agreement, there's a process where the case is always going to go to some mental health professional to assess the situation, prepare what we call a child custody evaluation or an assessment, where they actually do an investigation and write a report with specific recommendations on what the custody order should be. They may do all sorts of things in these investigations depending on the issues. Certainly if there are issues of mental health problems of one or both parents, they may do psychological testing, perhaps on their own or through a separate expert. They may assess issues related to alcohol or drug abuse with collateral experts. They certainly interview parents and children, not very young children, but at least observe young children. They may do home visits, talk to other collaterals, grandparents, teachers, physicians, pediatricians, and others that might know something about the children. Sometimes these evaluations are very time-consuming and complex. If they're done through the arm of the court that does these investigations, sometimes they're not, you may not get quite the amount of time and care that you might if you went to an outside expert that you're paying, which maybe I need to clarify here. The court has within it a group of mental health professionals that work in family court in what they call family court services. These are mental health professionals, not all, some psychologists, people with other credentials as mental health professionals who perform services for the court in child custody and visitation disputes. They provide mediation services, and in California mediation is mandatory. So at some point you will go to mediation to try and work out your custody case, and if you go to a private mediator, that's fine. If not, the court will provide one for you at Family Court Services. They do what are called emergency screenings, where they take a quick look at immediate short-term problems where there are allegations perhaps of child abuse, neglect, or alcohol abuse, or some serious allegation about a parent or both parents. And then they do these evaluations or assessments where they make recommendations on longer-term custody orders or modifications of orders. You have an option of going out privately and using a private mental health professional by agreement of the parents.
Okay. Wow. When will supervised visitation apply?
Well, supervised visitation is something that comes up when there's some serious allegation about a parent's ability to act in their role as a parent. Drug abuse, alcohol abuse, perhaps some recent criminal record, arrest, domestic violence situations. So where there's some very serious allegation and some finding that there is a reason that a parent shouldn't be alone with the children. So these are very serious cases, and surprisingly, these allegations come up with fairly regular frequency. And it's often amazed me where you could have people living in an intact marriage, raising their children with no allegations, then the divorce comes and all of a sudden the other parent's a horrible parent. So these issues are often disputed. Sometimes they're true, sometimes they're not, sometimes we don't know. You get an investigation that may be equivocal and you don't really know one way or the other. Is this parent really engaging in these bad behaviors? Are the children really at risk with this parent? Where there are allegations sufficient for supervised visitation, usually something is put into place to give that supervised parent the opportunity to work out of it, whether it's going to AA meetings, individual counseling, domestic violence classes, or some hoops they jump through And if they show they've done what they need to do, they may then gradually get their children back on something more normal.
Okay. Who is the supervisor for these supervised visitations?
Well, first, there are companies that do this for profit,
Okay.
and it can be very expensive. They charge by the hour, and it either can be at a supervision center, or in some cases, you can actually hire a supervisor who will go with the parent that's being supervised. So they may take the afternoon and go to Great America or the baseball game or out to dinner with the supervised parent and the children, and then they normally will write a report after each visit that's available for the other parent and ultimately the court in evidence if there's a dispute later.
Wow.
Or people who can't afford it, or people who can get along and agree on somebody, sometimes will agree on a relative or friend. So it wouldn't be unusual perhaps for grandparents to be supervisors. What we find though is when you have family members or friends supervising, they usually get tired of doing it, or if they're sided with the person that they're supervising, they don't take it seriously. They don't believe my son really isn't an alcoholic. I don't really need to watch him the way the court told me I was supposed to, or it's okay if he just has one beer. So you can run into problems with supervision other than going to somebody who does it for a living.
Okay. How long does the supervision requirement apply?
All over the place. I guess theoretically it could be forever if someone is unable to demonstrate at some point that they've resolved whatever the issue is that caused the supervision. Sometimes, I would say, most often it seems like it's fairly short term, months, 3 months, 6 months, the time it might take to get through a parenting class, show that they're in individual counseling for whatever their issue is. They're going to their AA meetings, they've shown they're clean and sober. There's some way they're able to demonstrate that they've really cleared up what the issue is. Now, sometimes I feel like it's merely the passage of time. They appear to have, as I say, jumped through the hoops to show that they've made a good faith effort, or at least a showing that they're addressing their issues, and now they get their children back, but it hasn't really resolved the problem.
Okay. What input does a child have on the custody decision?
Well, the law tells us that when a child is of sufficient age that they are able to express an intelligent preference, the court shall give weight to that child's preference. So what does that mean? I think most lawyers would say the magic age is perhaps around 12 for a lot of children. But I could see a 14-year-old that maybe is making very poor decisions and isn't able to clearly show that they have an intelligent preference. Whereas some younger children may have something very important to say that might influence the outcome of the custody case. It's something that generally we're hesitant to put children in that position. A lot of children really don't want to express a preference, except to each parent. They may say, gee, Dad, I really want to be with you, and the next day they tell Mom they really want to be with them. And then other children really call out for it, that they want to somehow express, they think they're going to have their day in court and be able to tell the judge what they think, and they'll write letters to the judge or to the social worker or somebody, or their parent's lawyer, hoping that their voice will be heard. And then in cases where judges recognize that perhaps neither parent is really considering the children's interests and wishes, they will appoint an attorney to represent the child to make sure that the child's interests are being heard.
Okay. All right, here's one of the toughest ones, I think especially these days, and that is, I think we're probably getting into the short rows here as finishing up our interview, but maybe you can talk for a few minutes about the situation of when one parent wants to move and maybe has the custody of the child or whatever. Yeah,
very difficult cases and very common. We have a very mobile society, I think particularly here in the Bay Area, We have a lot of people that come and go from other parts of the country and all over the world. And so folks may have moved here because one parent found a really good job here, and now their company wants to transfer them to New York or back to New Delhi or Europe or somewhere else. And the divorce comes, and one parent doesn't want to leave here.
Right.
And the other one feels like they're compelled to leave. Those cases are incredibly difficult because if somebody really is going to move, it becomes an either or. You can't really share custody with another parent who's living hundreds or thousands of miles away. The law tells us that if a parent already has physical custody in the court order, that they have a presumptive right to move with the child. There's a California Supreme Court case, Burgess, in re Marriage of Burgess, that tells us that about this presumptive right to move. But I think in practice, my experience tells me that most local mental health professionals that prepare these evaluations and make recommendations seem to have a bias against a move-away parent. And I think the court system somewhat has a bias against move-away parents. And even if you read the case law, how it seems to be applied in reality is maybe there's a little bit of a difference. So if you're a parent and you want to move away after the divorce because you're from, say, New York, your parents are back there, your siblings live there, you've got a job back there, you've got a difficult case to convince the court that the children are going to move with you.
Right. And not only that, but they lose, it seems to me the court would maybe be concerned about sort of losing control over the situation, because after somebody's outside of California, how are you going to enforce an order? I mean,
well, that's another issue we have often is jurisdictional battles about which state has jurisdiction over custody. There's a uniform act, the Uniform Child Custody Jurisdiction and Enforcement Act, that's adopted by all the states that helps resolve disputes, and they're fairly common. Does this case belong in California or some other state? Primarily you look, one of the tests is home state, where the children live continuously for the last 6 months. But I'm finding it more and more common to have international jurisdiction issues. You know, we have a lot of folks that work in this area that have immigrated from other countries to take a job here, which may be permanent or maybe temporary. I've had a number of cases where you have jurisdictional disputes because there's an action going in India and another one in California, or other countries.
Yeah.
But
so you get these people who come to work in Silicon Valley, from East India or wherever, and then for whatever reason they have to go back. They met a person, got married here, and now they're leaving because they got divorced and they're going back home.
Sure, and the spouse who didn't get the job here may have no other connection other than they came here because their spouse got a job and now they want to go back to their home country or state where they're from, where their family's from. There's no marriage. They're saying, gee, the kids and I want to go back to where we came from.
Yeah. So this is a really tough area. I think one of the most emotional, because we have an emotional tie to our children. They're a part of us. They're our claim to immortality, if you will, of our bloodline going on, and then suddenly we're wrenched apart and have these conflicts. So folks, I hope you found this a fascinating conversation as I have. We're going to post it at our website, along with the other interviews with Mark about divorce topics. It's financialinsiderweekly.com under past episodes. And if you know somebody's getting divorced, you may want to let them know about it, or thinking of getting divorced. Certainly thought-provoking. We'll see you next time on Financial Insider Weekly.